Yeah! Well, to know that the gavel's calling, let's get this session started. Hey, folks, grab a seat. It's time to get the scoop. Baker's in session, serving justice with a whoop. From sunny Cali courts to the heartland's dusty halls, we'll spin the yarns of trials big and small. Oh, Baker in session, tales old and brand new. Some make you laugh, some will leave you in a stew. Gavels dropping beats, witnesses take the stand. Join the fun, y'all, across this great land. Hey. Classic papers like OJ or that moonshine bust. Fresh headlines steaming hot. In Baker we trust. Murder in the Midwest, scams down south so sly. We'll break it down with grins, no need to cry. East Coast embezzlers, West Coast wild rides. Supreme Court showdowns where the big shots collide. From petty thefts to plots that twist and turn, Baker's got the stories that'll make you learn and burn. Oh, Baker in session, tales old and brand new. Some make you laugh, some will leave you in a stew. Gavels dropping beats, witnesses take the stand. Join the fun, y'all, across this great land. Famous folks in hot seats, underdogs who win. We'll cheer the verdicts, dive right in. Coast to coast adventures in the name of the law. Baker's here to share it without a single flaw. Hit subscribe, don't miss the legal ride. Baker in session where the laughs collide. Hey, how we roll.
Good morning, good evening, good afternoon, wherever you are, whoever you are, and what if any you might be, and welcome to the final pre-trial hearing in the Brian Walshe case. A case that a lot of people think will be an amazing firework. I am not that sure, because in this case you have Proctor, and is there something that they might bring up with Proctor so it can be kind of the Karen Reed 2.0 case? I don't think so. There might be some stuff from Proctor. Rumor is that there might be some risque photos of Anna Walsh out there. But is it going to be the same meltdown, poor investigation, shady people working in the back like the Karen Reed case? Not what I've seen in any of the filing or any of the other hearings. So it's probably going to be a normal criminal case with just one little part that the Commonwealth will be prepared for this time. I kind of think that they could hide it in the Reed case, and then the FBI found it, which made it that very, very explosive. But even though I don't have the biggest trust in the Commonwealth, I don't think they are raving idiots, all of them. So some of them must have come up with a strategy to kind of counterbalance the shitstorm that they will have whenever Proctor is going to be mentioned. Throw yourself on the floor, say, yeah, we had a shitty investigator. He's not the lead investigator in this case. So I think people are maybe hyping this a little bit more than it really can be hyped. But talking about hyping, Brandon is on a whole new mission today. Normally people are saying Brandon he's a little I think we will call him a cultural ambassador for Urban Dictionary, but today he has been very, very positive. And he says, be a friend, tell a friend something nice. It might change their life. We are in this thing together. But why even wake up if you can't beat USC? It took a little dark turn in the end, and I don't know who USC is, but go Gamecocks. And Brandon comes in and says, On Mondays, we buy bleach, because if you want a pair of kittens and find Baker making Marissa and Jamie Michigan mittens, you'll want to be effing blind. So the operative word of the day is Michigan mittens. Again, Brandon is really taking his role as a cultural ambassador of Urban Dictionary seriously, and today the word of the day will be Michigan mittens. And I, of course, will never ever recommend anyone to search those terms, neither USC or Michigan mittens. Baker, you're a real hunk. Well, oh my. Oh my. It was great joining Runkle the last hour and seeing all of you support him. That's what this community is all about. Well done, Baker. It is an amazing thing. If you watched my morning show, I might have been a little I'm not a big fan of people who instantly goes and try and say someone has an ulterior motive with what they're doing, especially a man like Runkle, who has raised a lot of money for a children's charity. But I think it's just the internet. Hey, Squabby. The internet will turn everything bad, because right now everyone is just going to hate, and apparently Runkle got some of that hate. And talking about hate, I don't know him, but a lot of you probably know him. Nate, the lawyer who was on Ricada back in the day, has his own channel. They seem to have found a brain tumor in him. He was supposed to have had emergency surgery yesterday, postponed it till today. And now it seems like it's coming one of the days. So hopefully it's not as urgent as they thought to believe to begin with. But if you are one of the people who like to talk to the big guy upstairs, maybe ask him to help Nate get over this as easy and trouble-free as you can. It's a scary thing. Again, I don't know him. I know him from the YouTubes, that's all. But we all wish that someone will help the surgeons who have to go and fix this problem, and that he will have a speedy and full recovery after. Because no matter if we know them or not, we don't want people to suffer any of these severe illnesses. And Nate is a young man. He doesn't need these complications in life. But also, when someone put out a picture of him with Nate saying, "I'm here to support my body," some people started hating on that. It gets a little tiresome to stream, to try and make people a little happier, and all you get is just shit in buckets poured all over you. On Mondays, we pray, because when you show up to the kennel to get your puppy and Baker is giving Jamie the Michigan mud puppy, there better be a God. Two words for today: Michigan mittens and Michigan mud puppies. Google at your own volition. Hey, RJ. Yeah, I don't know. All of my Dutch people went away. Helen from Holland went away. You went away. I think you're in Holland. Totally Not a Russian went away. Pimpernella went away. Maybe all of my jokes about being a Dutchman with a finger in a dike got to be too much for the Dutch. Were you not tempted to bid more than $8,100 for Janetti's tie? If I had the money, I would. Not to get the tie. I don't care about the tie. But to help out Runkle and the children's charity, yes. And the other was Alessi's tie, and I think that was 51. Alessi's went for 81, and Janet is for 51. I thought it was the other way around. Don't let a few assholes ruin over 95% of the good and kind people that donated monetary or participated for babies and kids. It's just, maybe it's because it's been a rough couple of months with a lot of online hate, with a lot of stuff going on where you're just thinking, I just want to get away from it. So this week will be a different week than my normal weeks, because normally I'll find a case, I'll jump on a case, and we'll do a case. Today we're going to watch the Brian Walshe hearing. Tomorrow, because Brandon has complained for half a year now that I don't use my Kenwood that all of my wonderful mods bought me for, not my mods, but my wonderful audience bought me for my 27th birthday. I will be trying to bake some scones tomorrow, some ham and cheese scones. Never tried it before. I'm not a chef. It might turn out to be an absolute crap fest. And then I will be making a cake that Jamie had found a recipe for. So that's what I'm going to do tomorrow. Just decompress, do something else. Wednesday, I don't know, maybe build a Lego set. Thursday, Karen Reed has a hearing in her civil trial. I think I'm just going to decompress and get away from all of this online stupidity. Now let's try and get some word games, since you're too lazy to cook. I just promised you I was going to do it tomorrow. I have zero self-control. I will Google these terms, then regret it, but thanks for the warning. Purple Pixie, you are grown up. I trust you. Today again, Randy Savage died because when he went to snap into a beef jerky, he ended up seeing Jamie dressing Baker as a Michigan turkey. I don't know what's going on in Michigan, but it seems like they have a lot of Urban Dictionary entries. And another thing I want to say about the fundraiser over the weekend, because I was on twice. Once when he was just getting through the first night, and then I went back on. I promised him that I would come back in the morning if he needed me, and luckily there was a lot of good people there to already help him, but I jumped back on just to try and get it into goal. I think it's amazing that all of these people, even though they might not be the bestest of friends or might have some animosity towards each other, came together and tried to help out with a fundraiser, because a fundraiser is what it is. It's not about you, it's not about me, it's about what cause we're raising money for. So I think that was really, really good. And talking about fundraisers, tomorrow night, Tuesday night at 6 p.m., there will be a fundraiser for Kelsey Fitzsimmons. It's her birthday, and I will be trying to, now I'm not doing a full day live stream. I'll get an hour nap somewhere and I will join it and hang out for a bit with all the cool people that has been so generously sweet to me and invited me. So that's what I'm also going to do tomorrow. Kelsey Fitzsimmons fundraiser for her birthday. And let's help others help others. Well, that was a big confidence booster for me that Runkle said, "Yeah, I'm going to the loo, so see you later." And I hope everything went well in those 3 minutes. But I might also have said something a little harsh to some people, because Runkle was almost passed out in his chair, and then they wanted to talk about politics. And don't do it on a fundraiser. That's not the time. That's not the place. It's not about what you think. It's about helping kids. The bottom line is we all just need to be kind to each other. Absolutely not. Everyone can be as big of an a-hole as they want, but you just don't have to try and force others to listen to you being an absolute a-hole. And are we ready to go? Nope. No. The last time I looked, it was 97,000 that he raised. Kurt does some kind of Zumba dancing too. Maybe you can both live stream your Pumbaa class. I was at the Cougar class today. Did well. I some days because I'm a fat guy who mostly lifts up and down. I don't lift on the sides, so it'll hurt my legs doing all of those, whatever we call it, stupid samba moves and stuff like that. But today went really well, and hey, I got my exercise in. I listened to some good music. I talked to some people. It's a win-win in my book. And Brandon goes even harder, saying, on Mondays we feel sorry because when they have nothing better than to shop a major, just get Jamie's with the sideways Michigan typewriter and just save yourself. Leave the kids in the pool. Just go. Go. Get away from it. Thank you, Brandon. I have so many words that I need to. Michigan Mitten. Michigan. What was it? Oh.
Is everyone ready?
Yes.
Are you ready?
I'm ready. And go away.
Giant TV in the back.
Giant TV. We have a hot mic.
She'll ask for him.
I think so, yeah. I thought there was. Like the gallery can look at it.
If we can have that, like,
Oh yeah, that's not fun.
Yeah. Let's see. It's all new to me.
I want to start yoga next year. I actually want to do yoga
kinda nice to
classes
whatnot on
for
the
the
process.
stretches, but
that's true.
all of the classes are evening classes, and
Responsible.
I have to be here at evenings because we start at. This is 3:00 in my afternoon. Kurt plans to do a workout stream with Bob Alessi. Good for him. Get to the gym, get moving. It's good for every one of you. Just do one little bit of exercise. You don't have to do it every day, but just get moving. Get moving.
Good morning, Your Honor. In the matter of the Commonwealth versus Brian Walshe, criminal indictment 2023-0091, the matter is scheduled for a final pretrial conference this day. Defendants represented by attorney Larry Tipton and Kelly Porges, and the Commonwealth by ADAs Greg Connor, Ann Yaz, and Tracy Cusick. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Gregory Connor for the Commonwealth. With me as Assistant District Attorneys Ann Yaz and Tracy Cusick.
Morning.
Good morning.
Good morning, Your Honor. Kelly Porges on behalf of Mr. Brian Walsh. Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
All right. Good morning to everyone. We bring the defendant in.
Today was supposed to be chest day, but my car had I had to de-ice my windows, and so I got it down there late. And I got a stupid alarm in my car. 2 of the doors doesn't unlock, and when I lock the car, they open. So I have to get it to the mechanic. The treadmill and I am wiping in the moment. That's I like audiobooks, or if someone is live streaming, just put that on so you can participate in chat. So you have something. I hate just walking on a treadmill. It destroys my brain.
With the court's
But
permission, would you feel comfortable if Mr. Walsh remained uncuffed, at least his hands during the proceedings, so we can take notes?
Check that with the court officers. I defer to them. I don't have any.
a real
probably no.
mechanic.
Okay,
I don't have any objection to that.
okay, I'll check with them, thank you.
I'll check with them when they come back in with them.
Okay, thank you.
But it's just annoying that I unlocked my car and then it just started click, 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 click,
I
click, click,
certainly
click.
don't intend to have his
So there must be
hands cuffed
something
during the trial, so.
Of course not.
like a switch or something that's not working. So, but I'll go to the mechanic in the morning because we have election day in Denmark tomorrow, and thinking getting out of bed early and go vote at opening, because normally I would be at a polling station all day, but haven't been invited this
I
year.
bought one this weekend.
So I'll be there when they open, and then I'll drive to the mechanic, and then I'll get my haircut that I was supposed to have gotten today and go to the gym.
Thank you, Madam Clerk.
It's when I hit the, and then it'll just make a warning sound. The doors are not closed, so every time I slow down, it'll try and lock the doors, and it can't lock them. But a mechanic is a mechanic. They have what I go to the brand mechanic, so they should find it out. Brandon isn't dead. Stop saying that. Hey, Anne.
The motions that came in over the weekend.
I can't do that because then I'll lose my will to live, and I'll start looking for the ocean like Brandon.
All set? Thank you. For the record, the handcuffs have been removed from the defendant so that he can fully participate in today's hearing.
It has
So,
happened.
the purpose of today really is to go through the motions and eliminate, see where I can
Oh, maybe I
give
need
you
to check that.
some rulings and some expected rulings.
But it opened fine
I
enough.
always say expected rulings because I like to think of a trial as a living, breathing thing that evolves, not something that is pre-planned. So these are my best guesses. Sometimes I'm making actually affirmative rulings because I know enough that I don't think anything will change, but if it does change, I'll let you know. So I'll just start. I'm going to go through those motions that we went through a couple of weeks ago in the same order as they're listed. Instead of, I'll start first with the pretrial motions. And what we have left over there are the following. And before I move to the motions and eliminate, I'll give you an option to check in on others that you think that I might have missed. So the first motion that I think needs tending to is paper number 184, which is the Commonwealth's motion for use of streaming platform to prevent juror exposure to extraneous matter with an affidavit in support. The defendant did not object. The request is to use the standard Zoom format. The court intends to do that. And so that motion is allowed. There will be no other streaming platform used in this trial other than Zoom. Any questions about that?
Your Honor, just briefly, there's the standard Zoom platform in which remote users are able to unmute themselves, and then there's the other version where they can't. I don't know what the name of that is. Are we using that version?
We're using the version that they can't unmute themselves.
Thank you, Your Honor.
Paper number 185 is the Commonwealth's motion for an order to prevent juror exposure. This is called the stay away, no contact order, so to speak. I don't know that we're going to need it. It's hard for me to judge or what is going to be the appetite for either demonstrators in this case. I don't see anybody outside yet, and I'm hoping it stays that way, frankly.
Your Honor, I think the parties are all also hoping it stays that way. In the event that there's any information suggesting that there might be any sort of demonstration outside, how could we communicate that best to the court, information that we might...
Through the clerk, the best point of communication always is Madam Clerk.
Thank you, Your Honor.
So if things change outside, and I have a skewed version of it because I sit out on the back, so I don't see what's going on out on the front of the building, but if it changes, you let us know.
The reason why they are talking about demonstrations is because Canton is afraid that it's going to be another K&R trial. It will not, because this is a way different trial. And the trial coverage was allowed. It's just, I think, the Zoom call that people can follow it on Zoom, but they have to, it has to be muted. That's how I understood it.
No, and I won't hesitate to order that because of premier importance to me is keeping that jury that we pick in their fair and impartial state throughout the entire term of the trial. So the supplemental questionnaire, I'll get that to you today. I did add in, as requested by the defense, I changed those 3 questions to be 3 separate questions. I added in the additional question that the defense asked. I think we, at the side of the bench on Friday, the Commonwealth indicated to me that it didn't have any additional edits to that. And I did see some motions came in this morning. I can't say that I spent a lot of time looking at any of them, but I did see that there was a revised witness list, which the Commonwealth eliminated witnesses that it no longer intends to call, and added a few witnesses. Which reminded me, so I'm going to, that witness list as abbreviated, we talked about cutting out the custodian of the records and adding in the defense witnesses to the appropriate subheading. And not on Friday, but previously, I think I said to you that, said to the defense to take a look at where I put them to make sure that I put them in the right bucket, so to speak. Have you had a chance to do that, and are you content with where I put them?
I know I looked at it, Judge. I remember, but I think that it was fine, and I'll take a look at it before I leave today, but I think it's fine.
Okay. So what I'm probably going to do is take the new witness list from the Commonwealth and then add those people back into the same spots that I put them on the prior version, rather than try to figure out who the Commonwealth took off. But sometime this afternoon, you're going to get the questionnaire and you'll get the attachment that I intend to, and just take a look at it for the final. We can always make changes in the morning. And while I'm on the topic of questionnaire, I think I told you, I think it's the most efficient way to get the information to you, and the least logistically challenging way is the way I've done it really in almost every case that I'm using a questionnaire now, which is those questions are designed in a particular way such that a yes response requires further follow-up. And so when that person comes in, and I'm pretty sure now that we're going to be impaneling in this courtroom. I didn't think that the last time I talked to you, but based on what's happening in the other courtrooms, I can't get a clear courtroom somewhere else. So we are going to impanel in this courtroom. We'll be using the whisper technology for strikes. And when the person comes in and is seated, I will follow up on any missing information on the statutory questionnaire and any yes answers to the questionnaire. And then I have a few more follow-up questions if the person's still standing and is still a viable potential juror. One of the questions that I think I'm going to ask in that individual voir dire is to tell the prospective jurors that during the course of the trial, they need to agree not to be on any social media, and they need to agree not to watch the news in any medium. That's a big ask, but I think it's a necessary ask given the level of publicity, media coverage in the case. Anyone have an objection to that?
No objection. No objection, Judge. Could I just ask a question, Judge? I looked at my notes from our last discussion. I read my notes to say you weren't going to give us copies of the questionnaire.
That's right. So how do I do that?
Yes.
So you'll have a blank questionnaire, of course. And so what I do is I have the person come in, I tell them in the impanelment script, you fill that out, give us your honest answers to the questions, you fold it together, and you keep that document in your possession. Don't show it to anyone until you hand it to me. So they will come up to the side of the bench, they will hand me the questionnaire. I will then recite. Juror number 40 answered yes to questions blank, 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 and blank. So you'll know what questions they answered yes to. And occasionally people don't answer, and they'll put a question mark, or they'll write something. And if that happens, I read literally what they wrote and where they wrote it. And if you at any point want to look at the questionnaire, that's fine with me too. I just want to prevent the both the time and the paper that's involved. Jury selection is so paper intensive anyway, the last thing you need is more questionnaires. But if you want to look at the questionnaire at any point, that's fine. And then at some point, the very last question, as you know, on the questionnaire says, whether this would disclose anything that would be personal to you. I presume that some number of jurors are going to answer yes to that question. At some point, typically at 1 o'clock, I will have the required hearing under URIP to seal those questionnaires. And you have to give, under the rule, you have to have a hearing. So it'll take about 2 minutes, but we will have that hearing at some point.
I haven't seen it anywhere.
Thank you, Judge.
I don't even know if he has a lawyer for this one, but I haven't seen it anywhere.
The
would be hard to
Commonwealth
do.
filed a preliminary request for jury instructions. I just want to bring that to the defense's attention with regard to the elements of all of the crimes, so that if there's any objection to that, the murder one is really the SJC's, and I don't know that you're going to be dabbling with that, but with regard to the others, just take a look at those so that we're all on the same page with regard to the elements that are attenuate to the other crimes, all right?
Oh my God, she's a slow
Yeah, Judge,
talker.
And at the appropriate time, we do have an objection to some of their requests, but we'll deal with that when the court wants to.
Okay. I think we're a little before that point, but I'll be happy to hear you whenever you want to bring it to my attention.
This trial hasn't started.
We've dealt with on Friday the motion for change of venue, and we also, I guess implicitly, if not explicitly, have addressed the defendant's motion for leave to conduct attorney-conducted voir dire.
Hey,
to the
Anime.
extent that the defense is asking for panel, I'm not going to exercise my discretion. I'm going to do the traditional individual voir dire. And of course, you play a big role in that. That's all I have for non-motion in limine pretrial motions that I think that I could give you some rulings on. Before I move to the motions in limine, is there any other non-motion in limine pretrial ruling that you're looking for?
Your Honor, the Commonwealth did file a motion for reciprocal discovery.
Okay.
The defense did provide us with a notice of intent to call Dr. Banerjee and an outline of Dr. Banerjee's opinion if she testifies. The Commonwealth is requesting the proposed potential testimony of Dr. Lakin and Joel Scaletti of Safos Corporation, who are identified as potential experts by the defendant, and also Dr. Dan Ferrier and Steve Verino of MVP Forensics, also identified as potential defense experts. And also Tim Creamer has been identified as an investigator. Commonwealth is requesting any statements that Mr. Creamer has obtained, and also the...
Someone get her an Arbinger already. I don't know what an Arbinger is. I will have to Google that as well.
Substance of any testimony he may offer.
It's everyone is just really, it's low energy. It's Monday morning.
We have no opinion, we have no reports, we have no statements. I will, though, provide them with a summary of what I anticipate the other experts would testify to. I'll do that. And I'll
All
do-
right, when can you get that to them?
Pardon?
When can you get that to them?
Wednesday?
Seems reasonable.
Arbinger is a misspelling of the word harbinger. Oh. I know what harbinger is because we talked about it the other
Any
day.
other non-motion and limine motions? All right.
Yes, Christine, the judge said that there will be access on Zoom, but it will have to be
So I'll move to the motions
muted.
in limine, and I'm going to take them in order, I think, with the exception of maybe one of them. When we get to it, I may pull that to the end.
Irregardless, I'll accept it anyway.
So, paper number 187 is the Commonwealth's motion to eliminate number 1. It's to provide the jury with a means to review electronic exhibits during deliberations, and the defendant did not object to that as of at least 10:31. Same position today, right? Yes. It's allowed. The Commonwealth needs to ensure that the laptop that is in the jury deliberation room is contains no other information other than the information that's necessary, the software that's necessary for the jury to review the material evidence.
We will do that, Your Honor. There is a special laptop that will be.
I think a lot of people got it wrong. They tried to do the, hey, we can't have any, but there will be a live stream and there will be Zoom access, but the Zoom access will be the version of Zoom where they muted from court. That's what she said, to not influence the jury. Remember in one of the pretrial hearings with Karen Reed, someone yelled in, "Free my boy, Brandon." I can't remember who they were trying to free, but right now we're trying to free Brandon. He is in a prison cell in Thailand. Long story. He's only allowed to stream my show and participate in that. But that's what we have been trying to cover up for 6 months. Let's just say Ricada and stuff is involved in it. But there will be an access to the Zoom feed as well, but it will be muted from the court. That was what she said, so no one can influence the jury.
Used for that purpose.
Billy Tibbetts,
Provided
yeah,
for the
free my boy
defense.
Billy.
All right, and that was the second part of my order, which is the defense is ordered to review that laptop before it goes in to make sure that we don't have any glitches. Paper number 188 is Commonwealth's motion to eliminate number 2. It's to a notice of any visual aids defense intends to display during opening statements. The defendant objected to that. Is the defendant still objecting to that?
It is. We are.
The motion is allowed. As to opening statements, I want to see any chalks that you're intending to use. It's for your own good.
Probably not going to cover
Because
that.
if I
saw the
determine
case,
that there's something on that chalk
parts of
that
the
is
case.
inadmissible, you are not going to be able to use it because you're not going to be able to turn it around. Go right ahead and state your objection on the record.
Well, Judge, I would just like to explain something. I object to it for a very simple reason. I've been doing this for 20 years. I've never had an objection in either my openings or my closings when I've used visual aids. Secondly, I only include visual aids that I know are going to be exhibits that are admitted. If I have any question about anything that I would use visually for the jurors, I approach the DAs, I approach the court, make sure that we're all in agreement that's an exhibit. I don't use
Then why are
charts.
you objecting to it then?
Because it gives, if I give it to the Commonwealth before I make my opening, they have a roadmap, they have a preview of what we're going to say.
Everyone's supposed to be getting a preview of the evidence.
what are chalks? Chalks are demonstratives. If you make an overhead or you make a PowerPoint or whatever, they call it chalks. It's just a presentation that you can use in connection with your opening statements, or if you have a witness who is going to explain something, you can make a chalk going over it. I never heard it before the Karen Reed case either. I think it's something they say up in New England. but what do I know? Only weird people live in New England, or so I'm told by my local New England ambassador, Marissa.
Not of my opening and not of my thoughts.
All right, I'm not going to engage in a discussion about this. Any chalks that you intend to use that are not agreed to exhibits need to be shown to the court and to opposing counsel.
Okay, Judge, just so I understand.
And it can be the morning of, but it's going to be before you're holding something up in front of 16 jurors that we spend 2 weeks picking a jury for. Not happening.
And I don't want it to happen, but let me just clarify something. I understand the court's ruling so far. Chalks, but not
Nipa problem. It's I have Danish as my first language, so we'll figure it out together. And please, if you have questions, they are not moving anywhere fast in this trial, so we can catch up. And Marissa, I know you are in Mid-Atlantic, but you hate the New England area. I don't know why, but you say that you find it like Panera Bread. You hate it with an unbridled passion.
what we know to be exhibits.
If you have, and I know you have, agreed to exhibits, then you don't need to address that. Those are agreed to. You know it's agreed to. You can show those. If you have chalks, different thing, that you want to put in front of the jury, I am not letting you stand up before the jury without me seeing it first, and the Commonwealth see it first. It can be the morning of, but I do not want you showing a chalk to our impaneled jurors without me seeing it first.
I understand, Judge.
Good.
All right. Paper number 189 is Commonwealth's number 3. It's for notice of any third-party culprit evidence. The defense has indicated that he understands what the rules are and you're going to abide by them. There's no ruling necessary. Paper number 190 is Commonwealth's number 4, notice of any proposed reputation testimony. It also relates to, I have them in my notes, see paper number 193 below. 193 refers to any bad character, bad reputation of the victim or any of the witnesses, and alleged prior bad acts of the victim or any witnesses. The defense has objected to that, arguing that he intends to bring in evidence of general reputation evidence. Is that right?
Your Honor, at this point, we don't have any notice of specific reputation evidence that we'd either offer through cross-examination or in any case in chief for us.
Okay.
The concern I do have is the Commonwealth has indicated they expect to introduce evidence, quote unquote, that Anna Walsh was a loving mother who never.
I don't get it. Was she arguing against that, or is she just nasty? He was arguing against having to show his homework, and she said, "I'm not letting you show anything to a jury that'll take us 16 days to impanel. So we'll have to maybe declare mistrial." I don't think that there's anything untoward by saying, "I want to see your chalks to make sure that, hey, jury nullification, let's put that on the last page of our chalk. Probably going to cause a mistrial. Not a good idea." They normally do this. I don't see the big problem why he was arguing that it was putting him in a bad light that they wanted to check his homework, but it's not. It happens a lot.
Have abandoned her children and was a dedicated employee. So I'm sure the government is aware of the restrictions on how this evidence will come in, but that may or may not be relevant. And so I'd ask the court to revisit this before they seek to put this information in.
All right, Commonwealth.
Thank you, Your Honor. Your Honor, the Commonwealth does plan to call witnesses who will testify as to their observations of the victim at her employment. Her employer will testify, as well as her former employer, who was the New Year's Eve guest, will testify as to her.
Is it Metlu or Mutlu, or how do you pronounce his last name?
Mutlu, Your Honor.
Mutlu?
Mutlu.
Okay, I'll try to remember that.
The Commonwealth will be introducing evidence to those persons regarding the victim's work ethic and
Observations or interactions with the children?
yes, Your Honor, observations and interactions with the children.
All right. I'm not going to give you any firm rulings on it. You raised your objections at the time. I will tell you generally that I probably will allow observations of her, not to an excessive amount, whatever that in my mind becomes excessive, but general observations as to the victim's interactions with her children is permissible.
Your Honor, I would just add that the law is clear on this. They can't have specific acts, so an observation would be a witness giving their opinion or testimony on a specific act. And so that's not admissible. What they're allowed
You're right, opinion or testimony.
So observations, how are observations of her with her children relevant, which I suspect may or may not be relevant once we start? And it can't just be a limited number of people. So one person from her work saying that she had a good work ethic, the case law says you cannot do that. It has to be the general reputation of a community. And so I guess we will just raise the objections at the time. I just wanted to put the court on notice that any of this testimony could just be inflammatory and prejudicial and invoke sympathy of the jury to hear that she was a great mother and a great employee.
All right. I hear your objection, and I encourage you, and I know that you don't need any encouragement to make the real-time objection at the time of the trial. And I'm just trying to give you some basic guideposts of what my present thinking is with regard to that evidentiary issue. Anyone want anything more on that particular motion?
No, thank you. Not at this time, Your Honor.
Commonwealth's
Untoward Marissa does Vegas for Boston cream pies. And proud of Broken Baker's teamwork with children's and hospital fundraiser. Runkle posted on X Money has increased. I think he's still trying to get just the last money in so he can go beyond 100,000. The last time I saw it, it was $97,734, and that was yesterday afternoon. So I don't know where we are at right now, but Runkle is an amazeballs human being. And thank you so much to all of the people who showed up and helped him get through 24 hours and participated.
Number 191, motion to eliminate number 5, is to allow in-court identification the defense asked for, and the Commonwealth has now given, I see this morning, a list of the witnesses who will so identify.
That's a stalker emoji.
Any issue that I need to be aware of with regard to that?
No, Your Honor.
All right. So that motion is allowed without objection, and the Commonwealth has satisfied the defense's request to provide names as of this date. Number 6 of the Commonwealth's motion to eliminate is to preclude reference to or introduction of irrelevant conduct of testifying and non-testifying police officers and agencies. The defendant objects, and I'm happy to hear further argument on this if you wish, but the defense's objection to me was, I wrote in my notes, it depends on what the Commonwealth does in its case in chief. And so you've alerted me to the issue, and we'll take it as we go along. With regard to a preemptive ruling in that regard, nor do I think that it would be part of your opening statement, because the opening statement is supposed to be a preview of what the evidence in the case will be. And so the defendant may not open on this without raising it with the court. It wouldn't be expected testimony at this point based on your opposition, or seek to introduce that evidence without readdressing it with the court affirmatively at the time that you're going to do it. All right? Commonwealth's number 7 is paper number 193. I think we just went over that with the other one, so I'm going to bypass that. Paper number 194 to Commonwealth's number 8, to admit photos of digital devices rather than the actual devices, and the defendant did not object, and that's current today. That motion is allowed without objection. Let me pause on 195, because I think we're going to have to go through. Let me just say, first of all, Commonwealth's number 9 is to admit the defendant's 4 recorded interviews with the police. I saw this morning, but I haven't really had a chance to look at it. The Commonwealth supplemented its legal briefing with regard to statements of Ms. Minor and of the minor child. I want to look at that, and I want the defense to have an opportunity to look at that. I looked the case over quickly this morning, but I frankly didn't have much time to deal with it. But I'm going to circle back to that motion, because I think we're going to have to go sort of on the micro level and start going statement by statement, which is going to take some time. So I'm going to put that towards the end of this hearing. Paper number 196 is Commonwealth number 10, to admit NCIC missing person form for Anna Walsh. Defendant didn't object, correct?
Correct, Judge.
It's allowed. Paper number 11 of the Commonwealth's motion to eliminate, to admit photos and a short video of Anna Walsh.
Queen Hearts of, I don't know what WA is, Washington. Is Proctor stuff going to come into play at all in this trial? This is what everyone is expecting. Everyone is expecting this is going to be the biggest firework since the Karen Read case. I think it'll be a wet fart in church. The Commonwealth will now have a strategy to combat that. They will most likely come out and attack Proctor before the defense can get at them. Kind of like we saw in the beheading case, that the defense started with, oh, she used to be a corn actress, she banged her stepson, all of that. So you got all the negativity out, so that the state couldn't use it against her. If I was the state and there is anything, the rumor is that he might have shared spicy pictures of Ann Walshe. But the thing we have not heard is that he has done what he did with Karen Reed. He had attacked her personality, attacked her lawyers, pinned it on the girl, talked to his sister about she should just jump off the planet. I don't think Proctor will be as big a part in this as everyone is hoping. I think Miles King is where it's going to be interesting, because apparently there's a lot of text in there where he has a very unhealthy view on people with a lot of melatonin. I think that is the case where the firework can really come in. If he has just shared some nudies, it's not going to show he had a bias against Mr. Walshe. It's going to show he was a dirty cop, he was an asshole, but he's not biased against the defendant. That's what Karen Reed's the text in the Karen Reed case showed, and it was an ambush because the state hadn't planned for it, because they didn't know that the FBI was going to give that to the defense, so they had to scramble. That's why they tried to diminish Michael Proctor in the second case, and the defense didn't even try to put Proctor in there because they knew that the state kind of knew where they were coming at. It's going to be trial strategy. Can you use some of it with Proctor? Yeah, he broke the law. Didn't break the law. He might have stretched the law with the Google searches, but the judge has ruled the Google searches are okay, so you can't really even question him about it. The problem with Proctor is you have to have him have bias against the defendant, a bias that could have tainted the investigation. We have had no indication so far that this case has shown any bias against the defendant. He might have been a pig and shared nudies of a dead woman. That's one thing, but that's not bias against the defendant. So I don't think Proctor is going to be as big a deal as people are expecting. On Mondays, we do chess, because if you got a strategy and want to combat that, you need a meter-long Swedish meat bat, so your moves better get swole. Pump those moves. Thank you, Brandon. The Commonwealth is going to avoid Proctor and pretend he doesn't exist. I would actually put Proctor front and center in my opening statements if there's nothing bad really other than him sharing nude photos. Because people in Massachusetts will know the name Proctor, and I would get ahead of it. The cases where it's going to be a problem is where it shows he has bias. And if you can find that he has talked about several people of color in a very negative way, you can use that against him in your defense, I would say. If it's just that he's a nasty asshole who shared nudies that he found on the phone, that's not enough that it can topple a case. That's just what I'm going to say. Don't Google anything Brandon says. No, it's absolutely not recommended. And the words of the day were Michigan mitten, Michigan sideways typewriter, and the last one I forgot. And this one was, we know what a Swedish meat bat is.
He normally appeared. The defendant objected. So I haven't seen the video. Does the Commonwealth have a way to show me the video?
I believe we could email it to you, Your Honor.
I meant like right now.
Your Honor, I have it on my computer. If you can give me a moment, I can walk up to the bench.
That'd be great.
No, we want to see the video.
Generally, what is the video of?
It's her with her 3 children on a rug in the living room of the home.
And why is it important?
The rug, an identical rug was found in the dumpster outside of the defendant's mother's home.
Your Honor, I can approach, but just what might make it easy is the video
Michigan
is
mud puppy.
unnecessary. They could do a screenshot of the video which portrays the rug in question. I can approach and I can show you.
Yes.
Sure.
So,
They can do that with a screenshot.
No objection.
all right, that's a ruling you were going to get, so it's good that you, there is no reason that the video needs to be played. So just take a shot of it, show the shot. Now,
I'll sit
with regard to the other photos, you need to use, it's sort of like autopsy photos, in my view. Use the least number you can use to get, I understand that's one
Thank you.
picture she's wearing a necklace, and one picture she's showing the watch or something else. But use the least number that you can use.
If I may, Your Honor?
Yes.
So I agree with that, and we tried to cull it down. So there's one with a jacket, there's one with a watch.
The black jacket.
Yes. There's one with a watch, and there's one with a necklace. We can probably take away one or two from what we submitted, because I believe that there's one where she's with Mr. Mutlu wearing the watch, so maybe we can delete that one. So we're talking probably about 4.
Your Honor, the other issue is those photos can also be cropped, and there can be a stipulation that the cropped photograph showing a person wearing the necklace, the coat, is in fact a photograph of Anna Walsh. So they have sent a parade of photographs. I think that there's other ways to serve that purpose, and some might be stipulations. So this.
Well, I'll let you work out whether you have any stipulations, but even if you want it that way, doesn't mean that the Commonwealth wants it that way. And the Commonwealth gets to, hold on one second. I gotta take a break.
Oh, something happened outside of court.
No, I'm fine.
Could we figure out what happened?
1 second. I gotta take a break.
Someone needed help. How much can we boost this? Let's figure out what happened. It sounded like someone was on the radio saying, need help. This is probably going to be a little loud, so protect your earbuds.
Commonwealth wants it that way, and the Commonwealth gets to, hold on 1 second. I gotta take a break.
Maxime something? What the hell? I couldn't get what but there was someone asked for help over the radio. I didn't keep fast forwarding. I backpedaled. Marissa, you stop lying, but I can go down to normal, and then we can go up. And I don't fast forward when we are sitting here listening. It's like talking to Jamie. It's just lie upon lie.
Hold on 1 second.
It sounds like something Maxine.
To, hold on 1 second. I gotta take a break.
Don't think we've seen that before. Oh, it's a short break.
All right, I think I was saying that you may be able to reach a stipulation. I don't know if you can, if you can't. But I think I was just about ready to say that the Commonwealth gets to, within the bounds of the evidentiary bounds, gets to present their case.
I appreciate the analogy to autopsy photos, and so let me go back and see if I can do something that's more palatable to the defense.
That's frankly how I see it. I mean, I understand the significance of the various items that we've just listed to the Commonwealth's case, or I think I understand generally what the significance is to the Commonwealth's case. So I'm inclined to let them have the photos that they're going to need to to make those arguments, but they don't need to be inflammatory. And so, yeah, just look through the lens of an autopsy photo.
Thank you, Your Honor. I
Comparable.
appreciate that, and I'll work on it.
All right.
Christine, go back and listen to the
Commonwealth's motion number 12 to admit
The
evidence
ruling. You
concerning
got
the
it wrong.
defendant's federal charges. And the defense is opposing in part. I'll hear from the Commonwealth first on this one.
Your Honor, we have actually attempted to develop a stipulation. The Commonwealth had sent it to the defense, and we haven't heard back as to whether that is something they wanted to stipulate to. We have been working on potentially reaching an agreement as to what information about the federal charges would come in.
All right. Well, to aid you in your discussions, it seems to me, and this actually overlaps with regard to the one of the other motions with regard to the interviews. I understand the importance of the federal case in terms of the Commonwealth's argument with regard to motive, and particularly the timeliness of certain information vis-a-vis the time that the Commonwealth indicates that they believe the defendant did the acts that he's charged with. And the one area that I wanted to probe so that I have the information firmly in my mind, what the evidentiary significance of it is, the weight of it versus the prejudice, is the GPS. So my memory from prior proceedings on this case is that the GPS was not the way that the Commonwealth found out that Brian Walshe was at various places.
That is correct, Your Honor.
All right.
It was not a GPS bracelet.
What was it?
It was a radio frequency bracelet that would go off if he went a certain distance from the home, and he would have allotted amount of time to leave the home to perform errands and drive the children.
Okay. So there's no evidentiary, there's nobody coming in and saying based on how his bracelet, he was at X, Y, and Z. They found that from the phone, right?
That is correct, Your Honor. They found
All
it
right.
through the two phones.
So that seems to me to be both in the transcripts and also just to the extent that it's in any of the federal papers as a condition of release, highly prejudicial. And I'm not inclined to let the jury hear about that. It's not relevant to their decision-making, and they may, even if I give them a limiting instruction, may make it difficult for them to accept the limiting instruction. It doesn't have any evidentiary value. So anything with regard to both in the interviews, which I know we're tabling for later on, and or in the federal records, that seems to me to have very little evidentiary value to the Commonwealth and has a potential for prejudice to the defense. So that won't be in.
Understanding you've made a ruling, can I make an attempt to change your mind?
Sure.
All right, thank you, Your Honor. I appreciate you giving me this opportunity. So with the defendant's ability to have windows of time that allowed him freedom to leave from the house, it allows the Commonwealth to show the premeditated nature of this crime and that he had windows to clean up after the crime was occurred.
That's a different thing, though. The fact that he has windows of time that he, or certain parameters that he has to be at home, and that comes up in the interview at one point when Attorney Minor makes mention of
Yes.
that. I don't know what we're doing with that yet, but
Okay.
putting that to the side, I don't think that what you just said about windows is the same thing as I'm saying about being on an electronic bracelet.
Okay. Okay. Because
I think there's different prejudice that attaches to those two things. The fact that he had restrictions, that he was on federal supervised release, and that he had some restrictions is going to be known to the jury. It's integral to the case. But the fact that he's on an electronic monitoring bracelet is a different thing,
Okay.
in my mind.
Thank you, Your Honor. I understand your rule.
But keep on objecting, as I know you will. But that's sort of the dividing line that I'm drawing in my mind's eye right now.
If you're hungry for a Philly cheesesteak but can't afford Marissa or even a Danish beefsteak, bend over and spread them beefcakes at dance class. Thank you, Brendan. I want to try a real chili Philly cheesesteak, not a Brandon recommended Philly cheesesteak.
And keep on working on the stipulation.
Yes, Your Honor.
Paper number 199 is Commonwealth's motion to eliminate number 13. It's to admit the victim's out-of-court statements, evidence of her state of mind, and the defendant's motive to kill her. The defendant is opposing it in part. I'll hear from the Commonwealth first.
Thank you, Your Honor. The Commonwealth would seek to introduce the victim's out-of-court statements to Alyssa Kirby and to Mr. Mutlu and to Mr. Fastow as to her state of mind, which was known to the defendant. Your Honor, certainly the defendant, the evidence will show that the victim had a meeting with a friend, Ms. Kirby, on the 29th of December and told her about the big argument they had over Christmas.
Give me a timeline because I want to have this in my head. She comes home on Christmas Day.
Yes.
Anna comes home on Christmas Day. She drives because she missed the flight. She spends much of the day driving, and then she gets there on the evening of the 25th.
Yes, Your Honor. I believe it would be around 8 o'clock.
When did she drive back?
She leaves on the 26th of December,
Okay. And she drove back to D.C.
and she drove back to D.C.
And then she returns back to Boston by flight on the 30th.
on the 30th.
All right, that's helpful. All right, go ahead.
Your Honor, on the 29th, when she's still in D.C., the night before her return to Boston, she goes out to dinner with her friend Alyssa Kirby and talks about the big fight that she and the defendant had. And
What didn't I read?
tells Alyssa Kirby-
She'd been home for Christmas.
Yes, over the Christmas break, or the day that she was home. She tells her about that big fight, that she gave the defendant an ultimatum, that she had learned that the reason the children weren't with her was because of the defendant and his attorney, and that she had told him essentially to just resolve the case, even if it meant taking jail as a result. And I know Your Honor has reviewed the paperwork, and it is a little more detailed, some of the statements of the grand jury. Your Honor, I would suggest that this is admissible because certainly it shows the victim's state of mind, that she is prepared to do what she needs to do to take her children down to D.C. to be with her. She had a very highly compensated job, and I know Your Honor is familiar with the circumstances
I said all the
of her
words.
moving to D.C. without the defendant and the children. I suggest that that is certainly known to the defendant. He acknowledged and alluded to a big fight over Christmas in the recorded interviews, and indeed said that he had learned after fighting with the victim previously over Christmas, and I believe he said Thanksgiving, that he was not going to fight with her over her alleged need to return to Washington, D.C. for a work emergency. I suggest this is highly probative of the victim's state of mind and the defendant's motive to kill her. It also shows that he is aware of this. He's searching Mr. Fastow's name. He's searching for divorce, and he is conducting those searches in between. I believe the search for Mr. Fastow was on December 25th, and then he's searching for divorce, I believe, on the 27th. His
It
mother
is.
then hires the private investigator to investigate.
I did say
Anna's,
cake.
whether
Beef
she's
cake.
behaving appropriately for a married woman. That's on the 28th. Certainly suggested all of this is highly relevant.
Brandon, can you get those contacts for your ears? Because I said beefcake in dance class. You're turning into the next Sue.
To the victim's state of mind and the defendant's motive to kill her and what happened in that home on the 1st of January. And with Mr. Mutlu, there is some testimony about Anna Walshe had some conversations with him, I believe on the 28th. And Mr. Mutlu's testimony is a bit indicating in some of his statements that some of it he might have learned from other people, but some of it he did learn from Anna. And certainly the Commonwealth would be very careful to make sure that we're only eliciting what he learned from Anna, not something he had heard from somebody else. And I suggest that that should all be admitted in this case.
All right. Defense?
Thank you, Judge. Your Honor, the problem I have is the Commonwealth is also cherry-picking parts of these conversations. The dinner that they're speaking about, her and her friend were out until 1:30 in the morning, a night that ended at a karaoke bar. So there was probably copious amounts of alcohol, I would assume.
But that goes to the weight the jury chooses to
Yes,
give to it.
But in the context, I think it's important. The other thing that the Commonwealth didn't seek to introduce is the fact that Alyssa Kirby at the grand jury, at her grand jury testimony, said that they had a very open and honest relationship, and that Anna wanted him to do whatever he had to do so the family could be together. And further, she didn't say that she wanted a divorce or was going to leave him with this ultimatum. Specifically, Anna supposedly said to Alyssa Kirby that she wanted him to choose life because he had been so depressed. And even if he had to go to jail, that will be waiting for you when you get out. So I think they're not only cherry-picking what portions of this conversation they want to put in, they're overstating the relevance, especially in light of the case law. When you look at the cases that talk about state of mind, they cite Castano. That was a situation in which the witness had told the defendant in that case that she wanted to end the relationship, that she had rejected his anniversary presents, not only was ending the relationship, but has packed up his bags. And when the police responded to the scene, there was, in fact, a packed suitcase of the defendant's items at the door. That is not what we have here, let alone to that level. In Martin, the statements that the government was seeking to introduce were basically statements in history of physical abuse, violence, of her trying to take the children from him. That is not what we have here. Half of the conversation to Ms. Kirby was how she wanted her family together. They had an open relationship. Couples fight, so to say they had a big fight on a date, she was late for Christmas and they had 3 children. This was not earth-shattering motive to kill information. So I don't think it's fair that these conversations with Alyssa Kirby come in, and certainly if the court does see value in those statements as the case develops, then the doctrine of verbal completeness would force the court to allow all those statements to come in, because this was one conversation. So that would be our position with respect to Alyssa Kirby. With respect to Jem, I think there needs to be either a voir dire or some clearing up of what he heard from other witnesses and what he specifically heard from Anna. And again, Mr. Mutlow was with them on New Year's Eve into the 1st of January until about 1:30 in the morning. And he's also described the night is joyous, that they had a happy marriage. The federal case had been going on since 2018. They had been weathering this storm. And so, again, if they're seeking to introduce statements, I think that the full conversation would come in to show the context, and we need to figure out what exactly Mr. Mutlow heard directly from Anna.
All right. So let me give you some guideposts. The defense in its opposition cites to Qualls, which is sort of one of the earlier and seminal cases on state of mind evidence. And but I'm not persuaded by the defense's argument with regard to what Qualls stands for in light of Castano, and in light of which, for the record, Castano's at 478 Mass 75, a 2017 case, and also look at Commonwealth versus Bins, B-I-N-S. That can be found at 465 Mass 348, a 2013 case, at headnotes 17 through 22. Under that case law and other cases that I looked at, it is very likely that I'm going to allow Anna Walsh's statements to Alyssa Kirby, the limited purpose of establishing her state of mind as is relevant to the defendant's motive to kill his wife, to the extent that such state of mind evidence includes statements describing his defendant's prior bad acts. His federal case on his statements will be admitted, and with a limiting instruction that it is limited to show the defendant's motive and not to show that he had a bad character or propensity to commit any other criminal offenses. There's a limiting instruction that is posited by the court, the SJC and Bins. It's on the bottom of top of page 419. Take a look at it. That's what I'm likely going to give you.
Him interrogating a 6-year-old, I would do whatever I could to get that tossed, because, again, that has to be specially trained police interrogators when it's kids. You have to be so careful that you don't put words in their mouth. It's really bad. And everyone stop saying that Sue is a know-it-all. She's not. Sue knows a lot of things, but she's not a know-it-all. That's a negative thing. The rule of completion always ends up old line Kardashians back from some query. What? Who?
I think that the parties need to do a little bit more work with Jem, and they will, as the Commonwealth gets ready to prep him for his trial testimony. And obviously,
They had a son and 1 or 2 daughters, I believe. The thing with Proctor is they were allowed to look at the son's iPad or something like that, and he looked at all of them. That's where all the Googling. No, he wasn't allowed to look at the son's iPad, but he did, and that's where the Google problem arose.
be in touch with the defense with regard to what that
Who's Monty G
pretrial,
called her know-it-all?
work reveals with regard to statements that were made directly to him from Anna, as opposed to third-party other evidence that would not be admissible.
Yes, Your Honor.
With respect to William Fastow, there's one notable exclusion or sustained you're going to hear. The statement that she makes to Mr. Fastow about she doesn't know what the defendant would do if he were to find out about the affair is not her state of mind evidence and is not admissible and is prejudicial. So don't go there.
Yes, Your Honor.
And then, of course, with regard to the doctrinal completeness, I think the defense has an argument there. And so I'm inclined to let them bring in the other statements. And you can oppose it if you want, but that's sort of the guidepost that I'm setting right now.
Understood.
All right. Paper number 200 is Commonwealth 14, to allow the admission of text messages conversation as of 11/12. I wrote the defendant had not filed a written objection. I think I invited that at our last hearing, and I'm guessing that you didn't because it's 801D2 stuff, but you let me know if it's otherwise.
So, Your Honor, with respect to the text messages, I think maybe we have some objections to some of the portions of the text messages, but specifically, and I did talk about this in
Another paper?
the defendant's response to Commonwealth Motion in Lim 13. The William Fasto text messages, I don't think that any of them are admissible and the jury should not receive them. There is no evidence about state of mind in them. It's text messages about two friends who are having an illicit sexual romantic affair. There's no evidence by the government other than speculation that Mr. Walsh ever even saw these messages.
Is it speculation? I mean, he says in his own words in the interview that somehow her text messages are showing up on my phone or something to that. And I'll go back and listen specifically, but we did cross this issue once before, and that was my recollection. Maybe it's a failed recollection.
No, the statement that you're referring to, there is a conversation between Mr. Walsh and the police where in the same paragraph he says, iMessenger, not iMessage, and then there's talk of Facebook messages popping up on its phone. So I don't think it's clear. And even if the court were to infer that iMessages came to his phone, there's no indication that those came to his phone. The text messages with Anna Walsh and Will Fasto ended at about 10:30 on New Year's Eve. Mr. Mutlow was at the home until 1:30. He specifically said, either during an interview or his grand jury, that at no point did he see Mr. Walsh on his phone. He didn't see Mr. Walsh on his wife's phone. He, again, described jovial, happy, up until the time he left at 1:30. So I think it's a very thin speculation that he saw these messages. If a foundation is laid during trial that indicates that he did see them or he did know them, it would be different. But otherwise, these text messages are hearsay and they're not admissible for any purpose.
How are they hearsay? In order, and what I'm focusing on is what in them, is to prove the truth of the matter asserted.
Well, then
I guess we'll have to look at each, and that's sort of where we're going to end up with the transcript, I suspect.
Well, then so it kind of reverses the question back to the government. Why are they seeking to put this text message history in? They're putting it in because they want to wave it around and say she was having an affair and he knew and he killed her. That's what they want to do. And I think if there was actual evidence or proof, other than speculation, that he had seen these messages, was angry about them, we'd be in a different posture. But that is not the case. And so why are they trying to put them in? And hearsay, her messages, her statements are hearsay. So what other purpose is it coming in for? I don't see a purpose other than to just wave this in front of the jury. Mr. Fastow is going to testify. He can certainly testify to the relationship between him and Anna, the duration, the time, but those text messages should not go in front of the jury.
All right. Kamala.
Please.
Your Honor, in addition to the defendant making statements about her iMessenger appearing on his phone, he also told the police that her phone was upstairs on New Year's Eve. He told police about some quarrel she had had with someone over text message and then had been put her phone upstairs in their bedroom.
Abdullah.
Yes. That's different than Mr. Mutlow's testimony that she was using her phone all night. So I suggest that's certainly...
Let me ask you this. Based on the forensic work done on the defendant's phone, is there any evidence that he was on his phone that night?
No, Your Honor, there's not.
Okay.
That's the phone that was
Missing.
misplaced.
Right. But you do have evidence, this has been the subject of other motions, that on the first and into the second, that there was some manipulation of that phone to unlock it. So I guess what I asked you, and it was a sort of a void in my mind of whether there was any evidence that he was on his phone on the 31st, and the answer to that is no.
The first time his phone was manipulated was at, I believe, 7:35.
In the morning of the 1st. All right, just trying to get the facts in my head. Well, more to follow on this as to individual text messages, and I want you to be focused on whether or not they are being offered for the truth of the matter asserted, and if they are, what your positions are, and see if you can make some headway on this.
Thank you, Your Honor.
Well, Your Honor, the only other thing with respect to the messages, and this could be an email instead of, I just wanted to We can certainly check, but if I could have the government verify if the messages they are proposing to introduce between Mr. Walsh and the other witnesses, if they have been edited at all, because we have like pages of text messages over a couple days to various witnesses, and I don't know if that is just the chunk that they are taking, or if they went in and cut out any messages.
Okay. And by the way,
I'll talk to the council afterwards.
Okay.
by the way, this motion that I'm talking about, we started to talk about Mr. Fasto and Anna Walsh's text messages. But to the extent that they're the defendant's text messages, which were the subject of this, then that's in a different bucket in terms of evidentiary ruling. Maybe not as important to you either, which is why you went to the other.
Right.
Okay.
On Mondays, we drive to Georgia because if you want to be the cork of the walk, you have to undock it from Sue's snooze, and both will be swole. Sue is absolutely swole because the Gamecocks won this weekend in an upset victory against, and it's probably the best Gamecocks team we have seen in a long time. Or Sue is absolutely miserable because the Gamecocks played like a bag of nuts, and it's probably the worst Gamecocks team we have seen in my lifetime. The corn actress was found guilty.
Commonwealth number 15 is to admit internet history from devices in the defendant's residence.
Your Honor, the government,
As I
has
said,
introduced two
horrible
binders that
Gamecocks.
They expect to introduce into evidence. One is a binder of the gray MacBook, and then the other one is a binder of, oh, okay, we have three now.
All right.
So we appreciate that.
Are these for my own, sorry to interrupt you, but are these similar, if not the same, from what came into grand jury?
They're not the same to what came into grand jury.
Okay, because I'm familiar with those from the prior briefings.
This is significantly more material than what came into the grand jury.
Okay. Is it the same sort of format, though? There's a search and then the result of the search?
No, Your Honor, this would, I would suggest, be from a Celebrate report, and we have copies here that we can give to the court to review.
Okay.
But the Celebrate report for the MacBook pulls from two different databases, so you see the same search twice or the same visitation twice.
So let me ask you this. I have some questions that I need to process in my head.
Yes.
The searches that are done, is there forensic evidence that shows that the searches were done on the MacBook Pro
Yes.
and not on the iPad?
Yes.
All right. That's what I suspected, but I haven't asked and nobody told me that. I assume that that was the case.
Yes.
Because that was not the state of the evidence, as you know, at the time the case was indicted.
Yes, Your Honor.
So, and from that time, and that is March of 2023 when the case was indicted, are you saying that the forensic work has uncovered additional searches beyond what was known at that time?
Yes, Your Honor.
Okay, and what's the volume of that?
So the MacBook report, that report that was generated is approximately 1,000 pages long.
Okay. Is that where this search, I hate to be so graphic, but well, it's not that, this isn't that graphic, but this, in paper number 201, I learned of a search that I'd never seen before, which is the,
We're objecting to that one.
right,
Okay.
so that was not part of the grand jury.
It was not part of the grand jury.
What is the date of that search?
That is, I believe, forgive me because there's so many, but I believe it's in and around Christmas.
So
It's
Pre-
before
January 1st.
Yes.
Also, he was always looking at.
Is it around the same time as the divorcing?
Yes, Your Honor.
Around the 27th?
If I may, I have a cheat sheet for myself. It's 12/27, Your Honor. And it is approximately 8 hours before the searches for divorce.
So, Your Honor, there were more searches and hits in general on this topic, as you might see on someone's device. This particular search, the name was, I'm trying to be, it was also about having a threesome and impregnating someone. There's multiple searches for porn. He is an adult male. So I think to just cherry pick this one, and
I don't care about the porn part, so to speak. I mean, that is the, it's inflammatory, but it's the second part of that search, cheating wife. So that goes to the issue that we just talked about before, about his.
I'm sorry. If he's searching for corn with a cheating wife, that's cock porn. That's not that uncommon. There's a lot of guys who like to watch that. I don't understand why, but if you're gonna cherry pick that he's allowed to search some corn, but if it contains the word cheating wife, it's an indication that he's gonna unalive someone. Bruh, come on now. Apparently, he was searching on getting knocked up corn as well. How can you tell in? Are they going to follow her for the next couple of months when she gets her ultrasounds and stuff like that? I've never seen that. Well, there is pregnancy corn out there as well. Whatever you want, the internet has it. So again, that's why Brandon has word of the days. There will be pregnancy corn. There will be rough corn, soft corn, hard corn. You can get all kinds of corn. The only corn you can't get is candy corn, because that wax demon spawned candy is not worth it. But it's online. But if he's allowed to watch stepson impregnates muscle mommy, like in the last case, and it has no bearing for the case, but because he's watching Coggold gets to watch wife cheat on him. I'm sorry. I'm sorry. I'm very, very sorry. But I think that's not okay to say one of them is okay, the other one is not. And we will not do any of the searches, but again, never ever Google anything we talk about. Will we see redacted ultrasound pictures in the trial? I don't think anyone is preggers. I just think that he was watching corn that had that in. Lindsay Gitani watched men docking. And I've told you before, that's when one man over another man's, and that has no bearing that she's an absolute crap fest.
His state of knowledge and what reasonable inferences can be drawn from that search being done on the 27th. That goes to that is an argument with regard to his state of knowledge on the 27th as to whether or not his wife was having an affair, right? I could care less about the porn part of it.
No, I understand. I think that without getting into a semantical discussion about pornography, I think that there's millions of different interests, predilections of what people might watch or like, and I think that it wasn't just cheating wife. It was cheating wife has threesome and gets impregnated. So to say that could have been ancillary to what the content of the material was. So I think it's inflammatory. So when the court...
So there's this body of evidence of searches now that are not in my mind, because they were, and it's not that it's inappropriate, that's why we have these hearings. But what would be helpful to me is if the Commonwealth, A, can provide me with those searches, and B, if you know, and it's not too much additional work, identify, and maybe it will become apparent to me, because there's only the list of what you knew at the time of grand jury is pretty much encapsulated both in the grand jury transcripts, but also in the...
I can tell you, if you put it into Google, it will be dirty websites that you'll get. All I can't even see how many hits there's on it. Yeah, Cornhub, X videos, XNXX, X videos, X hamster, Cornhub, X hamster, Ucorn. Yeah, people like stuff like that. I don't understand, but again, if it's a threesome, it's probably not the same. I think this is a BS argument. Apparently, because he watched a corn movie with a threesome where a cheating wife got impregnated, that means he unalived her 4 days later. Sure.
affidavits.
Your Honor, we're prepared to give you the binders and...
They start seating the jury tomorrow.
A list of the items that we would seek to elicit at trial from the binders.
Yes, ex-hamster,
And we'd give them,
without
of
an
course,
E.
we've given the binders counsel, but whatever we get to the court, we get to counsel.
And then if there are particularized searches that the defense is objecting to, I know you will raise them with me. And as a matter of logistics for how the jury is going to be presented, this is even the stuff from grand jury, which I printed out because I'm still old.
He does look like the mom from
Binders
Stepsons.
worth of materials that I have
Step Bros.
still with me. How are you going to present this to the jury?
So, Your Honor, we have, that would be tagged as an exhibit, a binder, but then it can be
Viewed.
broadcast on these different monitors. So we can ask the witness about a certain entry in the report and put the entry on the screen, and then have the witness testify from the screen saying, this is what occurred in this entry, according to the report.
All right. Just an awful lot of material for them to absorb.
We understand that. It's also important material to
I
the Commonwealth's case.
understand.
And so it's not an easy examination, but we do believe that it's important, and we've tried to make it as streamlined as we can.
All right.
Your Honor, just so the court is clear, I believe the government's position is that they're going to put in 3 or 4 actual binders into evidence, so the jury is going to get a giant binder of 1,000 pages. And so at what point does that become cumulative and prejudicial when they just drop by? And I'm just trying, is there a way to streamline this, or is there a way to cull some of it? Maybe that's something we can all work on. I just wanted the court to be aware that that is the intention.
More to follow.
More to follow.
All right. Paper number 16, to introduce Axios Investigations, hired by Diana Walsh, December 28th, 2022. Defendant is opposing. So what is it? Is the Commonwealth just seeking to admit through a person presumably that comes from Axios, because Diana Walsh is not on the witness list?
Yes, Your Honor.
So,
We listed her as a witness, Your Honor. We don't know if we're going to call her, but we did list her in an abundance of caution.
all right, I'll make sure that she's,
I apologize, Your
I
Honor.
don't think she's on there.
It
She's
could
not
be a
on the list.
clerical error, but
Okay, so keep that, so
It's
that,
also present in the court right now, Your Honor.
well, do you want to do anything about that?
I didn't know she was on the witness list, so I didn't move to, I didn't move to sequester her for this hearing. So I didn't understand that she was going to testify, Your Honor. I apologize.
All right, so,
I can tell you what I would intend to introduce at trial from Axios. It's just very simple, a contract that was executed.
right, which I've seen.
Yes.
It's a grand jury exhibit.
Yes, Your Honor.
What's the objection to that?
So, Your Honor, what's the relevance of someone who the government isn't calling as a witness to introduce something that they did on the 27th of December?
Well, the relevance, and frankly, I'm going to ask that Ms. Walsh leave the courtroom.
Thank you, Your Honor.
I can speak more freely.
Thank you.
Suggests that Diana Walsh contacted Axios Investigations on December 27th through email and phone calls, that she signed the contract, that she paid for it. In the grand jury testimony, Jeremy Dozier states that Diana Walsh specifically said, I don't want my son to know about this. So they're trying to basically say, she did this, we have no evidence that he was part of it, knew about it, directed it, paid for it, and it's just prejudicial
But
and
there,
offending.
I read somewhere, and it has to be in the grand jury, I read somewhere that the connection to the defendant is that she wanted to do this for some time because of the psychic, and that she went to the defendant or said to the defendant, I want to do this, and that he tried to rebuff her and say, no,
December 1st.
I think his words were, Anna's a good girl, and, she's not having an affair, something to that effect. But then I also read somewhere, it has to be, again, in the grand jury, that he then gave her the name of Axios. So even though he said, don't do it, he gave her the name of the company that she hired, right?
So if the government is going to elicit that information,
The only way that comes in is through Diana Walsh.
and they did not list her as a witness. So even if there was evidence that the government was planning to introduce that Mr. Walsh supplied the name, that doesn't indicate he paid for it, knew that she finally did it, was interested in the results. The evidence we do have is that the mother saw a psychic, and even the evidence suggests that when Mr. Walsh was speaking to other people about it, he was dismissive of it, and even told his wife about it. So I don't think it's appropriate that they get to introduce the contract or the fact that Diana Walsh hired a private investigator on the 27th, unless they're going to call a witness to link it to him and that he knew about it, wanted it, and was invested in the results. Otherwise, it's not relevant.
So, Your Honor, you were right about your memory of the grand jury testimony. That statement of the defendant giving the name Axios, that comes from his mother. So
But you don't have her on the witness list, so how do you make that connection without her?
that's fair. We were suggesting it's a reasonable inference by the amount of contact the two of them had, and that he saw her frequently, and that he talked to her frequently over the phone. But again, we were trying to be very limited with what we were entering. It was just the contract through the private investigator. So with that, I think Ms. Porges, her assessment of the evidence is correct. And so I don't want to belabor this issue. That was the only thing we were trying to get. We were not trying to get any statements of the defendant, nor were we trying to get any statements of his mother, simply the contract.
Well, you make whatever strategic decisions you're going to make, but that may lead for a paucity of evidence on linking his knowledge to it. That's your choice.
Understood, Your Honor.
All right.
Thank you for 2 months, 2 years almost, Marissa. And Brendan says, I am being verbally abused by chat, and I just am trying to figure out what plans the Austrian judge has for that clock box. I like this clock. Finally, something with a little bit of soul, some panache. I like old clocks. I like old clocks, and I cannot lie. That TikTok drive me wild.
Number 17 is paper number 203, and no objections to the calendar.
There isn't, Your Honor, but given the fact that my understanding is that there's going to be a blank calendar and items or notations may be placed on it, and I'm assuming then that is going to go to the jury. If that's the case, then the defendant would also like access to also add or denote things on that calendar. We can color code it, we can figure out a way, but that's what I would ask for. Or we can have 2 calendars, which seems superfluous if there's one.
We were just looking to give each juror an empty calendar so they can make their own notes and it would be part of their notebook, not something like that witnesses would be using.
So
Okay.
if they just want to give a blank calendar to the jurors so they can keep track of days, then that's fine.
Yeah.
Yeah, it just got confusing during the grand jury.
All right. 206 is allowed, sequestration of witnesses. 207 is a review. Commonwealth took no position.
Your Honor, may we be heard sidebar?
Yes.
Side by side by side by side by the side.
So paper number 208, which is now we're moving to, did move at paper number 206 to the defense's motions eliminate. Paper number 208 is defense number
No, I am not in the US. I am in Holland.
3. That is now mooted and requires no ruling. Paper number 209, defense 4. Commonwealth has indicated they will not seek such opinion, so no ruling is needed. Paper number.
No, it's not his second. They postponed his emergency surgery to the day after, and then they pushed it so it would happen maybe today, maybe later this week. So it went from very serious to okay, serious. So that's a good thing.
210, defense number 5. Commonwealth will not seek, no ruling is necessary.
Your Honor? Might we ask that a similar order regarding any awards or commendations for any defense experts that may be called? That they may not elicit that from those experts?
Yeah.
Well,
Do
to the
that.
extent that it goes to their qualifications, they need to do that. They need to know that the person's qualified, but no excessive lauding. How about we say that? On either side. Paper number 6, defense's motion in limine regarding any opinion that the defendant knew about the extramarital affair, and that was opposed by the Commonwealth at paper number 230. And as I understand the respective positions of the parties, is the Commonwealth's position is it's not seeking an opinion as to that, but is going to plant breadcrumbs such that a jury could, or could not, but they're hoping they could, infer the same.
That's right, Judge. They've told us they're not eliciting an opinion, so that
Right.
answers that.
So that seems to be the line that the rules of evidence draw as well.
I think it's his mother.
Paper number 7, defense number 7. What did I write here? is paper number 212, and it's regarding opinion evidence, and the opposition was at 231. And I wrote to myself, what more do you want? And under what authority?
Well, all I'm trying to do, Judge, and all we're trying to do is keep these witnesses from taking the stand and start offering opinions as opposed to the facts of their investigation, that they not be asked opinions that they have not provided in all of these reports. Because when you read through the hundreds of pages, and what they've given us is all this search data and everything, that's fine. But they can't then elicit, do you have an opinion about what this means? They can't do that, and that's why we filed this motion. That's all.
I'll hear from the Commonwealth.
Thank you, Your Honor. Your Honor, we've provided voluminous discovery in this case. Certainly, we expect that the witnesses will testify as to what they did in conformance with their reports. They'll explain their reports to some extent, but the defendant has all this material that has all been provided. So we would, if there's something specific they're looking for, but again, the witnesses will not stray beyond the reports that have been provided.
All right, then we have no disagreement. As an aside, by the way, it's somewhat surprising to me as I was looking at this issue how little is said about experts in the context of, or how little is required by the rules in stark comparison to the civil rules. And I can't resolve that in my mind why the drafters of these rules sort of make a heavier burden on the parties in a civil case with regard to expert testimony than is expected in a criminal case. I don't know why. Curious.
If I may?
Yes.
I suspect it's because in criminal cases you have procedural due process bumping up against substantive due process, and that's not present.
Wouldn't you think that that would then err to the side of more disclosure for the defendant?
I think less because fair trial strategy, and that might be different. That would be my thought.
My thought when I was sitting in the back is why don't they have to produce what they have to produce in a civil case? But I don't write those rules. I just try to interpret them.
I don't want to belabor this point at all, but I remember Stephanie Page filing motions for depositions because you allowed depositions in civil cases.
Right.
And we were always shut down saying no, and we asked the same question the court's asking.
Well, I'm asking that question, and I almost never allow depositions in a civil case, even of the experts, but regardless.
Why are we having this?
Anyway, defense number 8, paper number 213, opposed at 232, and then another rebuttal at 281. To exclude defendant's request to consult with an attorney or statements of prior counsel. And I got more on that today, I think, too. Let's pause on that one. Bad Acts, 214, paper number 9 for the defense. I think we've discussed this. It's opposed by the Commonwealth in a partial opposition of paper 233. And I had written to myself in my notes, question to the defendant specifically, what additional statements from the recorded interview does he want to exclude? But we're going to get to that in a minute. Paper number 215, defense number 10, motion eliminate regarding witness characterization of evidence or of the defendant's behavior. The Commonwealth has said it will not seek character evidence, but will offer evidence of the defendant's behavior through observations. Is that right?
Yes, Your Honor.
All right, that seems reasonable and likely where the line's going to be drawn. Number 11, paper number 216, asking the Commonwealth to designate and provide notice of specific statements and internet searches contained in the digital data seized to be introduced at trial. Anyone wish to be heard more on that issue?
Your Honor, the Commonwealth did file a response to pleading paper 234.
I saw that. I will say that the Commonwealth's opposition at 234 seemed to take a reasonable approach, and likely where the line will be drawn. Is the pillowcase in the pillow, that's all over, right? There's nothing there.
We're not going to introduce it, Your Honor.
And there's nothing other happened with regard to this is just a hanging, dangling from the prior motions, the dinosaur, teddy bear, that's nothing I need to worry about.
Nothing you need to work on. We sent counsel a list of photos we were intending to introduce. I think that we cropped out any images like that, and so if there's any issues, they'll let us know.
All right. So how do we take on this, what the remaining issue that I really want to address today, and then I'm happy to talk to you about anything that you need to discuss with the court, is these transcripts. And I had about 5 minutes to look at the case that the Commonwealth has now cited in its most recent briefing of this morning, and I want to give it a closer look. But one way that we can approach this is to literally go line by line. I know that the defense has indicated, and I appreciate the way that this was laid out in the briefing, because it makes it very clear as to what it is that you're seeking and helpful. So I appreciate the work that you did to get that in that shape.
This is because this is a normal trial. Normal trials are just procedure. No one is trying to pull a fast one. No one is arguing. That's why all the people who expect this case to be the next Karen Read case will sadly be very, very mistaken about that. This case will be a normal criminal trial. This judge is not Bev. She is not going to try and hide everything. There's no McAlberts in this case. This is going to be a straight down the road criminal trial.
And you've stated your objections. So one way I could do this is to just go through on this list that you gave to me and rule at some time between now and before the evidence is played, and give you a little bit more time to brief it. I will say that, as I said to you at the side of the bench on Friday, that I think that there's a evidentiary issue that needs to be decided with regard to what the scope of the employment of Ms. Minor was. And I'm not sure how this new law fits within that analysis. If it does, if it's just a separate analysis, it almost seems like it's a separate thing completely. And a separate vehicle or...
It will have less Proctor issues than the Karen Read case has. Let's all just, again, calm down. This case will have very, very minimal Proctor issues. All he did was go a little bit too far with what he was allowed to download. The judge has ruled it was absolutely in line with what will be allowed in court. There is no bias shown against Mr. Walshe in any of the things we have heard so far. They can try and the worst thing that potentially could be with Proctor is that he might have shared some spicy photos of Anna Walshe. But he's already been fired, and it doesn't show bias against the defendant. The problem with Proctor in the Karen Read case was his actions showed bias against the defendant. The case everyone should be keeping their eye on for Proctor problems will be the Miles King case, because if it is true that Proctor doesn't like people with ancestry in Africa, it'll most likely be that case that will show a high bias. This case, if it's just because he was an asshole who shared nude photos of a dead person, he's already been fired. What more can you do? It doesn't show that he botched an investigation like they did with the Karen Read case. There's no indication he had any intention to botch it like in the Karen Read case. People are thinking that's going to be fireworks. The fireworks will be the Miles King case because that will have a racial component to it. This one, it's not going to be. This isn't the case where Proctor is going to be the problem.
Avenue to admissibility, these adopted admissions. But I want to give the defense time to respond to that because it just came in this morning.
No, it's just procedure.
As to many of these statements, and so that you don't misunderstand where I thought I was on Friday.
No, I'm not saying that women should calm down. Everyone should calm down. Everyone is trying to hype this up as this. It's not going to be what everyone believes. It's not going to be the burning down of Canton PD. Because this will most likely be that he was an asshole who shared some nudes. That we haven't heard, like we did in the Karen Read case, that he clearly had a bias against the defendant. Because bias against the defendant would make him unable to do his job properly. Not probably, but properly. So I would look, if you want Proctor, the Proctor blow up to happen, I would bet on the Miles King case. This case, I maybe there's one or two of the other detectives who was on his text lists, but this case is not going to be the Proctor case. The Proctor case, in my belief, will be the Miles King case.
Which was alerting you to the issue of agency, I'll call it. And I don't want either of the parties to...
Oh, yeah, but they don't give a fuck in Massachusetts about the chain of custody. I thought you knew that. They don't care about chain of custody. That's and again, the judge has ruled that it's absolutely fine to use the evidence they found. We haven't heard any motions filed today about any of the evidence to be excluded. The judge will allow all of it in. So we can sit on the outside and say, yeah, that's BS, but this will go before the jury like any other case. And I don't think everyone who is believing this to be the next Karen Read case will sadly be very mistaken. There's a lot of circumstantial evidence where there was non-circumstantial evidence in the Karen Read case. There is a history of a potential breakup which could lead to a motive. In the Karen Read case, there was the opposite. He was begging her to come drive him home. In this case, she's saying, I'm going to leave you. It's a totally different setup. Did the police cut some corners? Absolutely. But different cases, and it's not going to be the next Karen Read case. Trivia time. This one has always felt like a circumstantial puzzle, and with Proctor hanging over the whole thing as a quiet wild card, even as a simple pretrial can turn interesting fast. Yes, I wrote it that because I need to sucker some people in to watch it, Brandon. But now people are here, and I can say it. If I had that, it sounds like what I wrote in my description. Also, Rosemary is very different to Tipton. Tipton seemed to be more calm. Rosemary will bulldog everyone being sus. That's also a very big part of it. What defense attorney is there? How much? And Alan Jackson is very different from a Dave Yannetti. We've all seen that. The bulldogs will bite.
To be misguided by what I said to you on the side of the bench with regard to that. And what I mean by that is this.
It's
Even
probably
if
from
Ms.
my
Minor's,
description.
Attorney Minor's statements aren't coming in, even if
I
they
don't know.
weren't coming in, I never intended to not allow the Commonwealth to tell the jury that she was present there. So whether her statements come in is very different than whether her attendance at the interview was going to come in. And I think in the opposition that
No, they haven't been trying to keep any of Proctor's bad acts out. Proctor hasn't been mentioned today.
saw, the papers that I saw flying, I think the Commonwealth, maybe based on what I said at the side of the bench on Friday, thought that I was excluding the latter as well. That is, her attendance at the interview. I also want to remind you of something that I said at the side of the bench on Friday, which is much of what Attorney Minor says is repeated by the defendant. And so the cumulative impact of those statements is not significant for the most part. There may be statements that she makes that are significant. It seems to me, and I'm sure the defendant is going to ask for the humane practices instruction. And if that is the case, it would seem to me that the dynamic of what is going on in that home during those interviews is relevant to that, specifically Thomas's role. I see you nodding your head no, but then I get to the later interviews. Maybe there's not enough in there for you to care about it. So why are you nodding your head no over there, Attorney Tipton?
I appreciate the time to respond. I was reading their cases at 4 a.m. That's not the best time to be reading cases. If the court...
I was blissfully ignorant of it at 4 a.m. I didn't see it until 7 a.m.
So if the court's... we will file a written response. My understanding is the court's going to give us time for that. And when's a good time to have that filed? You said you would make a ruling before the evidence started, so
Right.
I'm just wondering...
I mean, honestly, the next couple of days, we're going to be busy with picking a jury, and maybe even longer than that. So, I mean, I don't, as long as I rule on it, yeah, as long as I rule on it in time for you to make the appropriate edits, and I don't ruin, you know, the poor IT person that's going to be tasked with doing the edits, Thanksgiving. How deep into the cases are these transcripts coming in?
Potentially the first day, Your Honor.
Great, thanks.
But the good news is like you said, a lot of it was cumulative. And so in going over that, particularly the interview in the 7th, when we looked at it, we're like, there's really not a big problem with a lot of these. So we'll start working on some of those redactions. And we gave a list to the court of the things that we didn't object to. So we're going to start working on this.
So curiously, and I just want to make sure that this was a conscious decision on the defense's part and not something that was unconscious. There's some of what she said that you kept in. You know that. Well, attorney,
No,
there are some statements that you did not ask to be, and so,
from Tracy Minor, Judge?
yes.
Well, then that was an error. That's the highlight didn't carry through.
Okay, all right.
Because, and I don't want to interrupt the Commonwealth, and we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it, so I want to set that groundwork.
All right, I appreciate that.
2, I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Minor. Our prejudice, contrary to what the Commonwealth argued in their memo they filed last night, we made it very clear what the prejudice is. The prejudice is from the fact that Tracy Minor is there and all these statements are being made. Not the statements necessarily of Tracy Minor, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail, but that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor. And I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Minor was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there, and so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid. And finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Minor being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that preview, and I appreciate the reminder with regard to the humane practices, both for myself and also to the Commonwealth as we move forward and try to resolve this issue for you.
And could I just make one more suggestion? If the Commonwealth could take the highlighted sections that we provided to the Commonwealth and you.
Yes.
And just now, take those highlighted and maybe color code all of these statements they've listed. Wouldn't it make it easier for us all?
Well, I think we can get down to, I think if you get rid of the cumulative stuff, you're really probably down to not a lot.
Right.
So that might be a good idea. What do you think about that?
I think you're right, Your Honor. I think that the issue became with the transcripts, once you started taking her out, it became confusing. So she would actually ask a question and he would answer it.
Right.
Or she would correct him on the restitution figure 3 times in a row. So then he's just shouting numbers out and it doesn't make sense. So a lot of it was just confusing with what was being proposed. So we're trying to go back and be more strategic about this.
All right. And so my goal is to make things clearer and easier for the jury
Yes.
than confuse them. And so to the extent that that you're having that situation where there's a question that she's asking that he's answering, and it's cumulative, the relative prejudice, I understand the argument, and I'm not ruling on it right now, Attorney Tipton, because once she's there for one answer, she's there, your argument is going to be the prejudice attaches. I understand the argument. But it's also incumbent upon me to provide evidence to the jury that they can, in a manner that they can consume it. And if it's doing so, once I balance the prejudice in a way that allows them to digest the evidence, but I'll think more about the prejudicial issue. And maybe you can get, there really is not a lot that she says that he doesn't repeat. So how about Friday on that color coding?
Yes, Your Honor.
All right?
I don't need any Snickers. I have said nothing. Please stop constantly doing the, oh, you're grumpy, because we can just end the stream if there's any problems. I have just
That's all the
said
motions
people
want.
should not believe this was the next Karen Reed case.
Yes, Your Honor.
All right. The jurors that were called in, not much else that I have other than the jurors that were called in today were being used for a civil case. They're going to be told at the end of the day that they're being held over till tomorrow, and that's so that we will get a big yield tomorrow, and hopefully both, I'm hoping to take 70 of the jurors tomorrow, and the remainder will go hopefully to Crim 2 so that they can get their work done too. And then every day they're going to be held over, so we will have jurors right through till Friday, because as you know, typically we don't get jurors on Friday. And we'll seek to 16. Any questions that you have lingering that you need answered between now and tomorrow morning on anything?
No, but I would ask kind of sidebar on an unrelated matter to this case.
Okay.
When it's on.
Anything the Commonwealth needs?
No, Your Honor, I think that we'll work together and try and figure out some of the other issues we've talked about today. I've been keeping a running list and just trying to make sure that we stay on schedule.
All right. I will see you at the side of the bench.
So, an absolutely normal final pre-trial hearing. They have some last-minute details they need to figure out. Proctor will be used to... Oh, that beeping is annoying. Proctor will be used to try and show that the Commonwealth had dirty hands. But I still don't believe it'll be as bad as it was in the Karen Reed case and as it will be in the Miles King case, because we haven't heard any real bad stuff connected to this case other than potentially some nudie pics. I think you can survive sharing nudies. I'm not sure you can survive having a police lead detective, maybe a second detective, have problems with people's skin color. So I don't think this will be as bad for the Commonwealth as everyone was expecting when it came out, because the hope was way back in the beginning that when we found out that Proctor was so dirty that they would lose all the Google searches, because they are one of the biggest element. Well, there's, of course, the rock found in the dumpster. There is the blood in the basement. But also there is some Google searches there that is quite bad for Brian Walshe. If they could have kicked out, that would have raised the probability for reasonable doubt in this case a lot. But the judges have ruled they're fine, even though Proctor went further than he had discretion to do. So I'm not sure it's going to be as bad. But I don't know. It's not the most interesting hearing, because it seems like they are two teams working well together. Well, there's a very, very, very big difference. If you are racist towards the defendant, That's very different than showing pictures of the deceased person. It's one of them shows that you have a bias against a person. The other one shows that you're a pig. You can't say that because he's sharing nudes of the victim that he has a bias against the defendant. That's a very, very big difference. That'll be very hard to say, well, because he shared these nudes, he didn't like the defendant. If he said, look at this asshole who had these pictures and he killed her anyway because she's hot, then you can say he had some bias. But if he has a base setting that everyone who is black is a bad person, that will bias him in every case. So there is a big difference between those two scenarios. They did way more than they said they would. Nope, not frustrating Bukaki all over us, trusting Bukaki all over us. They did, yes, but the judge has ruled it's okay. There has been a ruling. It's okay to use the Google searches. They were overly broad and they were beyond the scope that was agreed upon, but the judge have ruled they are okay. We haven't heard one word today about it other than, hey, maybe don't use his porn habits against him. That's all we have heard today. Just because he liked to see some type of corn, you can't say that against him. The Google searches will be allowed in, even though it was a breach of the agreement they had. Yes, this UK action, absolutely agreeing. Proctor isn't interested in Cohasset. I don't know what that means. Well, I hope something makes you rumble on a Monday. I don't know why you can't type Snickerpuss. You did it this time. Well, what bias does it show against Brian Walshe? You can't just put everything on trial. You can't just say, well, Brian Walshe was jaywalking, so he's a bad person. You have to have a reason to introduce it. Yes, Michael Proctor will be brought in most likely. Michael Proctor would be put on the stand. Michael Proctor will be tried to be painted with, oh, he's such a bad cop. By working with Michael Proctor, every other cop is also a bad cop, which I believe they are. I believe there should be a big internal investigation. That's why even though people who are way closer to Massachusetts believe you shouldn't say stuff like that, I believe that everyone who goes to any arrangement with any up-and-coming DA candidate should ask them 3 very easy questions. Will you find out who killed John O'Keefe? Do you believe that there should be made an external investigation into all of these bad cops and the culture that has been there? And how will you promise that the culture left by Michael Morrissey will not continue under you? But I'm told, shut up. They're going to point at a DA and we're going to love that person. I believe all of these cops should be fired. I believe everything they have touched need to be looked at one more time. But it just doesn't change what we are coming up to now. And there's a very big difference about showing pictures of a victim and a defendant. That's just how it is. Cohasset is, I don't know where, I don't go there. It's not, yeah. Yes, that's a whole other piece of the pie. It shows that these cops are assholes. It shows that they have no moral. It shows that there is an accepted dirty cop culture at the DA's office. But it doesn't show that this investigation wasn't done properly. And that's what the defense need to show, that because of this attitude, they didn't do their job. They just pointed their finger at him, didn't look at any of the other evidence. And we just haven't seen it in any of the filings in this case. I haven't seen those filings where you think, oh my God, why didn't they look at this or that?
So the plan is we'll see each other. We'll end today's work. I appreciate the commitment to do some further work on issues, but I think we're really in pretty good shape
Yes, Your Honor.
as we move forward to the start of this. I will get you later this afternoon what I believe is the most updated witness list, which will be attached to that supplemental questionnaire. Take a look at it carefully, and I made some changes, some other minor changes that you'll see in there.
And I think we'll be able to give the court the binders of the internet stuff with spreadsheets of the isolated ones that we're looking at.
All right, that sounds good.
Thank you, Your Honor.
Have a good day, and we'll see you back here at 9.
This one won't get tossed because there's just not enough bad stuff here to toss the case. What we have here is just bad cops, but not bad cops making a bad investigation. That's you. There's different things that is important for if you want to toss it out or you want to toss some evidence, you have to prove something. We know in this case the evidence that Michael Proctor touched, the Google searches, has been accepted as evidence by the judge. So that's going to be the big old problem, because they can paint him with the bad brush all they want. The Google searches stays in. And Google searches is good evidence, in my opinion. Sounded kind of like they were on a wild fishing expedition with hey, he was looking at this type of corn 3 days before, so he knew she was having an affair. I don't think you can say that. But Proctor will not be the thing that breaks this case. This case will go forward. It'll go to trial. It'll be a normal case. There will be at some point where the defense will try and use Proctor to show that this is not done fairly because Proctor is an asshole. I don't believe it'll be strong enough to turn over this card. I believe the Miles King case will be the case where Proctor will be the biggest problem for the Commonwealth, because if he has a racial bias that he has shown not only against defendants but also against fellow police officers, he has a, what would you call it, a ground level setting in his mind that people of a certain origin are bad people, or lesser people, or dumber people, or whatever else there might be in the text messages, which will show that he is biased against these people. And it's the bias part that if you want the card to be overturned, you have to show that they closed their eyes, didn't look at the evidence, just went with the first guy they pointed at because, hey, why not? Kind of like Karen Reed, they looked at nothing else. Nothing. And when you saw Proctor's text messages where he said, well, we have to protect these people, more or less, is what was in these text messages. It showed that he was biased and didn't do his job. In this case, he actually did his job a little too much because he went further than he was allowed to with the Google searches. And as long as the judge has already ruled these Google searches are okay, Proctor will not be the linchpin that destroys this case. I'm just saying. But they can bring in that he has been fired, that he has had ethical violations, all of that. But that will be one cop that they can discredit by doing that. I just don't think it's enough to throw all of it out there. Is my problem. Proctor felt that about women, long history of misogyny. The defendant is not a woman in this case. So again, it has no bearing. Again, was Anna Walsh on the stand, then his misogyny and sharing of the nude would be an issue. But it's not her. She's the victim in this case. It's very different. It's the opposite. It's bad taste. It's wrong, but it's not the same as if she had been the defendant. You could use his misogyny against him. You can't use his misogyny against him in this case, because then he should actually be doing less to try and convict a man if he hates women. So it shows that he has a bad character. It shows that he's a bad person. It shows that he's a soulless piece of shit that should probably go somewhere very hot where a guy called Lucifer runs the show. Other than that, it just shows he's a bad cop. And there's tons of bad cops out there. And it's not enough to overturn the evidence because, again, had it been bad enough, the judge will never have allowed the evidence he collected into the case. It's not this case that's going to be the Proctor case. I believe Miles King will be the Proctor case. That's, again, any upcoming DA candidate, ask them about that. Are you going to make sure that every case you will go through all the hundreds and thousands of pages and documents found on Proctor's phone and make sure this hasn't been an ongoing thing? And will you make sure everyone who ever received one of his text messages will be looked at? But don't say that because then some people will tell you, what do you know about politics? I'm thinking, what the hell? You're talking about sheetrock. Okay. But this was a standard pretrial hearing. Nothing really contagious about anything except that the state want to put a little too much in there. And I think the judge seems fair, saying, hey, don't be overly annoying and put everything in there from date of birth to what star sign everyone was. Just try and keep it at a minimum. Don't show them all the bad pictures. You should be able to do it in 3 or 4 pictures. All of this stuff. I think the judge seems really fair in this case. I haven't seen anything where I think, nah, she's a slow talker. She's a really slow talker. Hopefully it'll perk up later. But she seems okay. She makes ruling on the bench. I didn't think you could do that in Massachusetts. They will be working on all of these hearings till December 1st is when this case is set to begin. But they will start to select the jury already tomorrow. So I don't know if they might be able to push it up if they get a jury faster, or they are saying, no, we keep it at December 1st. Let's get on the other side of Thanksgiving. I don't know what the rules are for that. But all in all, it seems like both sides are having a good relationship to each other. So hopefully not too much shenanigans is going to come on in this case. The Justin Root case, well, that case is done because he caught, was it 36 bullets? So a lot of people have been talking about it, but again, the next DA is going to be the same as the one they have now. Nothing's going to happen in Massachusetts. That's the biggest problem. And people are closing their eyes and just accepting it. I would be on the barricades every single day and telling the party that's going to nominate the next DA that we want change. No, we're just going to close our eyes and say everything is fine. Massachusetts is going to absolutely change nothing, not one thing. And it's going to be absolutely fine by most of the people who should be enraged by this. People who should use their online platform to demand change will sit there and clap like seals and say, well, it's my party and I cry if I want to. Well, you're going to cry later because nothing's going to change and you're going to wonder, we did exactly the same as we always do, so why didn't everything change? Isn't it wonderful how nothing changes in politics? Do I like scones? Yeah, I have no problem with scones. I'm going to try and make some savory scones tomorrow. Yeah, it's the very definition of insanity. But again, instead of making infights and stabbing each other in the back like the Free Karen Reid movement jumped right into, they should have come together and demanded political change. And they didn't. I got shit on when I said, why the hell? I asked the exact same questions Betterow asked, but I got shat on, not Betterow. Wonder why? Because if it's my party, it's okay. I don't like that. Cheese and scones are just rude. You should have them with jam, but I like them with chocolate in them. That's how I normally made them, but Brandon was asking for some savory bakery, so I think I'm going to try and put some ham and cheese in some scone-like substance tomorrow, because truth be told, I'm tired of trials. I'm tired of all this negativity. I'm tired of just because I'm not smiling, I'm being told I'm a grumpy ass. So either I'm going to bake tomorrow, or I'm not going to stream tomorrow. I don't know. Because I don't want to be surrounded by negativity, no matter where the fuck I'm going, if it's on the Twitch or if it's on a stream. I really just want to have a little bit of fun, cover some stuff, talk about some things. But now it seems too much like work and not enough like fun. So hopefully it'll be better tomorrow. Hopefully morale will improve, or Jamie will beat all of us with the belt, and everyone should not look forward to that. It's Monday. It's the first day in a new week. Go out. Stop doing what you did last week. Do something different. Don't do all of the... Stay away from the spaces on the Twitch. Stay away from all the idiots who are going to tell you that this person is that person and this person is attacking this person. And find something new and watch on TV tonight. Stay off all the social media. And if you're a man, give a love tap on your significant other's bottom and say, hey, honey, you're looking especially fine today. If you're a woman, give a love tap on your significant other's bottom and say, you're looking especially fine tonight. And maybe there will be some brown chicken, brown cow in it for you, or at least you'll make them smile and say, oh, Monday doesn't have to be the worst day in the week. We need to get away from all this negativity. And I'm going to go away from it now.
I'm Jimmy. How y'all doing?
I know English is your second language, but you don't word
It's
your
my
questions
third,
carefully.
but I'm still better at it than you. You are
the most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a